All right, welcome back. We now have our Insider Trading 360 panel, and the perfect moderator of this panel is Dan Hawke, who is a partner at Arnold and Porter. Previously, Dan served for 16 years at the SEC, where he was chief of the SEC's market abuse unit that is responsible for focusing on insider trading. And Dan was also director of the SEC's Philadelphia regional office. Dan, I always love hearing from you on these insider trading issues. Welcome.
Thank you, Bruce.
Let me next introduce John Barr, a partner at BakerHostetler and a real pro in both SEC and related criminal matters. John served for over 6 years in the SEC's enforcement division before going on to be an AUSA in Washington, D.C., and then a trial attorney in the DOJ's fraud section. John, great to see you. Welcome.
Thanks.
Just a few years ago, Rob Cohen was our keynote speaker on the West Coast when he led the SEC's cyber unit. Before that, Rob was co-chief of the SEC's market abuse unit. Now, Rob is a partner at Davis Polk, where he focuses on representing companies, boards, and individuals in regulatory matters and internal investigations. Very grateful to have Rob with us. Welcome, Rob.
Thanks, Bruce.
And finally, Joe Sansone is the current chief of the SEC's market abuse unit. As I briefly mentioned a minute ago when I introduced Dan, this is the specialized unit at the SEC that uses data analysis to investigate complex insider trading rings and other abusive trading schemes and misconduct. So if you want to know what's going on at the SEC in the area of insider trading, you speak with Joe Sansone, and we can't wait to hear Joe's insights today. Welcome, Joe.
Thank you.
All right, Dan, let me hand it to you.
Great. Thank you, Bruce. And I think we'll pick up with where Bruce left off and turn the initial topic over to Joe Sansone. We're going to talk about highlights in the past year concerning insider trading enforcement. And Joe, in August, NPR reported that the SEC Enforcement Division had a significant decline in the number of insider trading cases. Can you share with us the highlights from the past year and answer the question whether the SEC has abandoned its insider trading program?
Well, thank you, Dan, and thanks for that question. Thanks for the opportunity to be here. I want to start with a disclaimer that's probably pretty familiar at this point in the day, which is that the opinions that I express are my own and don't reflect the views, necessarily reflect the views of the commission or the other SEC staff. Let me take your question and start with the piece of it that relates to SEC enforcement actions this year, and I want to talk in particular about the role that data analysis plays in the work that we do, which was something that was also mentioned in the introductory comments, and then I'll circle back to kind of the broader question about the program. I think to sum it up, I think that the program and the SEC's focus on insider trading has not changed. The importance of these cases to ensuring market integrity remains a focus. And in fact, I think that what you've seen over the past several years is an increased focus on data analytics and a focus on bringing even bigger cases and focusing on bringing and rooting out the worst misconduct. So I want to focus on a couple of different areas. One is insider trading that is international in scope. And we filed a series of cases in 2019 into 2020 that definitely received attention, but I'm not sure that because they were filed over time, that the whole story really came out as fully as it might have otherwise. And these are the SEC, starting with SEC versus Taylor and Windsor, which involved insider trading by two investment bankers in London, a couple who worked together to tip traders on more than 15 different M&A deal announcements. And the reporting on this, not surprisingly, focused on their relationship and the pet names that they used for one another, and in particular the spreadsheet that Dorena Windsor created to track the payments that they would receive for their insider trading tips, which she labeled Popsy, which was her pet name for Ben Taylor. And it's natural to want to focus on the human aspects of these stories, and to try to understand what drives people to engage in these schemes. But what I want to focus on is the scope of the scheme itself, which, as you can see in some of our other filings, including SEC v. Cohen and Nikas, and SEC v. Feingold and Malnick, the broader scheme involved traders in Switzerland, a trader in Greece, a trader who spent time in Monaco and London, as well as another insider at an investment bank in New York. And these traders used accounts held all over the world in accounts owned by BVI entities in Hong Kong, accounts in Denmark. And really, I think, the case is kind of a tribute to, or what it reflects is the role of SEC data analytics in piecing all of these strands together. And that's not to take anything away from the staff's work and really tremendous work that the staff has always done to uncover great evidence like the spreadsheet that I mentioned earlier. But really, the analytics, the ability to identify trading by a group of traders over time who trade in a series of M&A deals, and being able to track that back to a specific, or in this case, 3 different investment banks, is really, I think, a significant advancement that we've made over the years. And what it really allows us to do is to focus and devote resources to these really difficult cases, and to collect evidence from all over the world in order to put them together. And it gives us great evidence to be able to go into court and freeze assets, which we effectively did here. And another, I think, positive aspect is that it tends to focus on the worst conduct. It focuses on intentional and really sophisticated schemes that in some cases go on for months, if not longer. So I think that this is this is sort of one example of the SEC's focus this year. The second focus is on cases similarly, on cases that involve quarterly earnings announcements. And there are a handful of cases that we filed last year. I'll just mention them quickly. SEC v. Nellor, SEC v. Bora. And these cases, again, involve quarterly earnings announcements. And similar to the case that I just mentioned, again, involve patterns of trading over time. And again, represent the SEC's attempt to go after, the worst conduct, conduct that is intentional, conduct that is involves, a high level of scienter, and that continues for some period of time. And so that's kind of the, an overview of some of the cases that we've been bringing. And, to circle back, I guess, to the question of, the number of case filings. I think that, that is one metric. And it's certainly something that we look at, but I think that you also have to look at, the quality of the cases. And it's really hard to compare a case, that involves, one instance of insider trading to some of the cases that, that I'm talking about, that we've been bringing, that involve, many instances of trading, multiple traders trading across numerous accounts, and you can't really compare those two things. So, I think that again, you have to kind of look at the quality of the cases, and I guess I'll just also say, and I don't really want this to be the focus, but we obviously there was a government shutdown last year, and we're living through sort of unprecedented times right now in terms of dealing with the COVID pandemic. And I think that we've been very successful, but, there are definitely, some work that we need to do, in order to adjust and to adapt to those things. And I think that, we've been successful, but these are hurdles that everybody is facing in this world that we live in.
Great. So, John, the Second Circuit earlier this year upheld the use of Title 18 in criminal insider trading cases. Can you walk us through that decision and what the implications are for insider trading cases going forward?
Yeah, sure, Dan. I think in December, a divided panel of the Second Circuit issued an opinion in a case called the Blaze Check case relating to tip-or tippee criminal liability, insider trading liability, that's generated a lot of discussion from those of us who practice a lot on the criminal side, really for two reasons. First, the court found that the required personal benefit element for Section 10B tip-or tippee liability did not apply to criminal insider trading cases brought under the wire fraud or the Title 18 securities fraud statute. And then second, the Second Circuit ruled that confidential government information may constitute property for purposes of the wire fraud and securities fraud statutes. Just to give you a little rundown on the facts, Blaze Check was a political intelligence insider trading case in which two hedge funds hired Blaze Check as a political intelligence consultant to try to determine what the Center for Medicare and Medicare Services was going to do in terms of setting reimbursement rates for various medical procedures and treatments. He had previously worked for CMS. He had some pretty unique access to CMS employees. He would speak to employees at CMS. He'd find out what the proposed rule changes that would reduce reimbursement cases would look like, and then he would tell these hedge funds, who would then fairly ingeniously, and it never surprises me how ingenious some of these schemes are, but they would then figure out which public companies would likely be affected by these reduced reimbursement rates and then short those stocks. And at the end of the day, the Blaze Check, people at the hedge funds, an employee at CMS were all charged with insider trading under Section 10B, which we're all familiar with, and also criminally charged they were criminally charged with Section 10B violations and also wire fraud and Title 18 securities fraud, as well as Section 641 conversion of government property and conspiracy. Interestingly, the jury acquitted all of the defendants on the Section 10B securities fraud counts, which required a showing that the tipper received a personal benefit for providing the MNPI to the tippees, and that the tippees were aware that the tipper had received the benefit. However, the defendants were convicted on wire fraud counts and the securities fraud counts that were Title 18 securities fraud counts. The trial judge in the case had refused to instruct the jury that the element of personal benefit applied to the wire fraud counts or the Title 18 securities fraud counts. The defendants appealed it, arguing that, look, the Title 18 counts and the Title 15 securities fraud count are each premised on, scheme to defraud. The Second Circuit had not acknowledged that, but then determined that the Exchange Act's statutory purpose, which was to eliminate the use of inside information for personal advantage, made the elements different in the context of a Section 10B prosecution. The defendants also kind of appealed on this determination that pre-decisional CMS information could be property under the Title 18 wire fraud and securities fraud statute, arguably because the CMS had a purely regulatory interest in the information under Cleveland versus U.S., which was not enough to constitute a property interest. The Second Circuit kind of analogized the case to the Carpenter case, which was the famous Wall Street Journal case, and said that the pre-decisional CMS information was very much like the timing and the content of Wall Street Journal articles, and that they did have a property interest in it. I think there's a couple of key takeaways here that have generated a lot of discussion in the criminal securities bar, which one is the case kind of results in the odd circumstance where the elements for criminal insider trading prosecutions, at least on the Title 18 side, are less onerous than those under Section 10B. I think it kind of leads to a bizarre result that criminal authorities, at least theoretically, could bring cases that the SEC could not bring. I think there's the cases on a cert petition's been filed. It's really a well done cert petition. It kind of emphasizes, I think, some pretty interesting holes in the appellate opinion, including kind of the issue that the Section 10B is kind of a general catch-all fraud statute, and this idea that it has a very limited statutory purpose is, I think it'll be interesting to see how the court takes that. I also think it'll be a little bit interesting to see how the court takes it because, you now have a bunch of textualists on the Supreme Court, and they might not be as receptive to that reasoning. On the property interest side, the Second Circuit kind of gave the back of the hand to this, Cleveland v. U.S. argument, which, that case figured very prominently in the recent Kelly-Bridgegate case that the Supreme Court came down with, that also where the Supreme Court kind of really slapped the department on the hands, I think, for kind of bringing these over-criminalized prosecutions, this prosecutions that the Supreme Court indicated really are kind of an over-criminalization. So it'll be interesting to see what happens with this. It certainly has generated a lot of discussion amongst criminal practitioners.
Great. Thanks, John. So, Rob, political intelligence, the Blazek case implicates political intelligence. Over the past year, there have been a number of news reports, including potential investigations of Senator Burr of North Carolina, and then news reports recently concerning For example, indications that the administration may have provided information or intelligence concerning the pandemic to certain market participants. Without obviously going into the details of those individual investigations, can you talk a little bit about, why those cases are hard from a political intelligence standpoint? And then if you wouldn't mind updating us on the status of pending insider trading legislation, that would be great.
Sure, thanks, Dan. I'm happy to. And let me just start with a personal note that some of the audience will appreciate. Joe and I served together as co-chiefs of the Market Abuse Unit for a time. Before that, we were co-deputy chiefs while Dan was chief. So the three of us haven't really gotten together to talk insider trading since Dan was our boss. So it's a great, I know, for me and I'm sure Joe and you too, Dan, to get together and talk insider trading. So, and speaking of memory lane, absolutely, there's been a series of cases that involve either political intelligence or maybe more broadly information either involving people from the government or where the government is the source. There's a Blazer case where information was coming from the executive branch, a particular agency. We haven't mentioned the Chris Collins case where the information was really not government information, but it involved trading by family members and acquaintances of a sitting member of Congress. And then the two news reports you've mentioned that as of now has not resulted in a case. And so we certainly don't know whether they will or what the facts are. We only know what's reported in the news. But the stories of the senator and then, as you mentioned, the reporting of an administration briefing or briefings. So all these cases sort of show that there's really some unique issues that come up when you're talking about trading either by members of Congress or trading based on information coming from the government. I'll just mention one or two of them. The first one is materiality. In a traditional insider trading case, materiality, is judged, after the fact by, looking at the stock price reaction after whatever the non-public news was when it becomes made public. It's not always that simple, but for the most part, if you're talking M&A announcement or a quarterly earnings release or a drug trial, you're talking about developments at a specific company, and those developments at some point become public, and you can look at how the market reacted to it. When you're talking about information from the government, it's more complicated. Government information can certainly be material and, of course, non-public, but in most circumstances, and in the news reports you mentioned from the last year, you're not talking about information about a specific company where you can wait and see how did this information affect the market when it came out by looking at a specific company's stock price. You're talking about the government's assessment of, the pandemic at a certain moment of time. And so that certainly has implications for the stock market, but exactly how material it is and how you go about measuring materiality is more complicated. Again, it's certainly possible that it's material non-public information, but it can be harder to prove for the government. The second thing I would mention is the idea of a duty. As practitioners know, insider trading really revolves around the idea of using information in breach of a duty. And again, in a traditional corporate context where somebody is tipping a friend or a business acquaintance or a family member, the idea of breaching a duty that you owed to the source of the information, either by breaching a contractual agreement or a relationship of close trust and confidence, is at least straightforward to understand. When it comes to the government briefings that you mentioned, it's an interesting question of duty. Did the people who receive that information have a duty not to use it for personal gain? If you're talking about, secrets passed in a one-on-one conversation where sort of the atmosphere makes clear that this information should not be passed on, that's one case. But where you have a group of people, even if it's a small group of people, but a group of people, attend a government, meeting, even if it's a private conference, but where there's multiple speakers, multiple people in attendance, I think an interesting question in that fact pattern is, did those people have a duty not to trade? Or was it safe for them to assume that if a government official discusses information in a group setting, that it's okay to use that information how you want? because if it was confidential, it wouldn't be shared with you that way. So those are interesting questions. And, what it leads me to is, what you said, Dan, about the status of legislation. So most of us or all of us know that insider trading law is entirely case law. It's made by judges in cases. There is not an insider trading statute. The references to 10b and 10b-5 for the most part. Over the past year, we've seen, I think, more progress towards a possible insider trading statute than we have in recent years. In the House overwhelmingly passed a bill called the Insider Trading Prohibition Act. It obviously, did not become law, has not passed the Senate, and I don't think any of us thinks there's a chance it's going to get passed with what the little time remains in this Congress. We'll have to see next Congress. But the fact that a bill was passed overwhelmingly on a bipartisan basis by the House, suggests an interest in legislation. So just real briefly, what the statute might change, at least in its current form, we'd have to see how it's reintroduced. As I said, insider trading law currently really revolves around the idea of trading in breach of a duty. Somebody, received information and it was wrong for them to have used it in the way they did because they owed a duty to the source, or they knew that the person who gave it to them owed a duty to somebody. The statutes take a broader approach and talk about the concept of information being obtained wrongfully. Now, violating a duty can be one type of wrongful receipt and wrongful use under the statutes, but it's broader than that. And so, for example, stealing information or obtaining information by hacking into a computer are very clearly covered by the bill as drafted and as passed by the House, where those are issues of some debate when it comes to litigation. Also noteworthy about the case, there's tremendous case law, as we know, about the idea of a personal benefit. What is a personal benefit? Who has to know about a personal benefit? The House bill keeps the concept of personal benefit, where it would if it were adopted, by the Senate. Interestingly, the committee led by Preet Bharara, former U.S. attorney in the Southern District of New York, who proposed their own legislation, which was very similar to the House bill, except it was different on this issue, which is the Bharara report would eliminate the personal benefit element. So I think for the next year, it's, obviously the new Congress may be busy with other matters, in the winter and spring. But, over the 2 years of the new Congress, it'll be interesting to see if the momentum that had been developed so far in the House, is continued and maybe gets picked up in the Senate. Great.
So, Joe, on the last panel, on the director's panel, Andrew Seresny talked a little bit about the concept of the implications of the Liu case on insider trading cases. Can you tell us, with respect to disgorgement liability, how you see Liu impacting the division's insider trading enforcement program, and specifically with respect to how disgorgement and penalties are determined in insider trading cases?
Yeah, thanks for that question. Just kind of expanding, I think that there's probably been some discussion of Liu, and it was discussed a bit in the last panel, but I think that the two pieces of the decision that are probably most relevant for the purposes of insider trading discussion are the concept of net profits and the issue of distribution to harmed investors. On the first issue, the net profits issue, I don't see that presenting major changes on the insider trading front. Currently, profits in insider trading cases are in many instances net profits calculated based on the price that the security was sold after the announcement, and deducting the cost basis that the trader paid for that. So there may be issues around the edges of that, but for the most part, probably not an issue for insider trading. On the second issue, and I think Andrew had kind of alluded to this, is the issue of distribution to harmed investors. And this is an area where, in most cases, the SEC has not historically attempted to distribute the disgorgement that it obtains from insider trading cases to harm investors. And the issue there is in part the difficulty of distributing, of identifying the harmed investors and distributing what would potentially be small amounts of money to them. And so it's really an issue of feasibility. And so the Supreme Court opinion really stopped short of addressing this issue as to what is appropriate in a case where disgorgement is obtained, but it's not feasible to distribute that to harmed investors. And so I think that what you'll be seeing is that, given the sort of the lack of specific guidance in that area, and I think what you'll see and what you've already seen is a shift and a shift to obtaining relief in insider trading cases using the penalty statute 21 Cap A. And fortunately for the SEC, that statute allows for penalties of up to 3 times the amount of the profits generated in the scheme. And so it gives the commission a significant amount of leverage to obtain appropriate settlements. And I think for the most part, what we're going to be seeking to do is really what we've always done, is to make sure that people who engage in insider trading aren't able to benefit from those schemes. And so, there are at least 3 cases filed in September of this year. SEC v. Hugh Lee, Robert Hodes Jacobs, and Craig Moyes. These are 3 SEC cases where the SEC obtained a 2-time penalty against these individuals who engaged in insider trading, but the SEC did not obtain disgorgement. This, I think, puts these defendants roughly in the same place as they would be had the SEC pursued disgorgement and a 1-time penalty, which was a common remedy in settled insider trading cases in the past. So I think, in short, we're going to be seeing a shift in the way that the SEC, at least in the settlement context, resolves these cases.
So we have a little bit of time left, and I wanted to focus for a few minutes on a case that is not an insider trading case, but raises the question of why the commission decided to charge the case under 204A, Large Cap A of the Advisors Act, and that's the case against Ares Management. That was a case in which Ares, which is a Los Angeles-based private equity firm and registered investment advisor, was ordered to pay $1 million to settle an SEC case in which it failed. The allegation or finding was that Ares failed to implement and enforce policies and procedures reasonably designed to prevent the misuse of material non-public information. And I guess for the next 3 minutes, if I could ask the panel, maybe beginning with you, Rob, what's your view of the Ares case? Is this a case where the staff couldn't charge insider trading against the individuals, so they went after the firm on a controls theory?
Yeah, thanks, Dan. So, obviously I don't know, what the staff's, thought process was, but I certainly can say that has been, the idea you just mentioned has been sort of a topic of discussion within the industry and within the bar, that may have been how things proceeded. I think what was really, interesting to people about the case was how deep in the weeds the case gets in an enforcement matter on the company's controls. So again, just a bit more on the facts. The firm had portfolio companies. They had individuals, or at least an individual on the board of portfolio companies, and the order talks about one portfolio company in particular. Ares would trade the securities of the portfolio company, which was public, while it had a board member. And, obviously that raises questions about whether Ares would have material non-public information due to its representation on the board. And Ares seems to have recognized that and had policies and procedures in place. In particular, the stock of the portfolio company would be on Ares' restricted list, so it could not be traded without a compliance review. It did have a process for a compliance review. Compliance would have to sign off on any trades. And in particular, Ares was very attuned to whether the portfolio company was in a blackout period, such that, it was improper for most people within the company at a senior level to trade because the company had material non-public information potentially, such as towards the end of a quarter, as is typical in public companies. And so despite those controls, the SEC order finds that that wasn't enough and that Ares violated 204 Cap A, which requires policies and procedures. And it seems that the order, really comes down to two main complaints about Ares procedures. One is the lack of guidance to the compliance department about how they should go about doing their compliance review, including, with whom they should speak to determine whether anyone at the firm had material non-public information. And then the second was the documentation. And I think, again, not knowing what the staff thought, but I thought an important finding in the order was a statement, not just that the documentation was not always adequate in the staff's view or in the commission's view, but that there were times when the documentation did not reflect if the review had been done at all. And so, the takeaways from the case, I think, are that one, even without charging insider trading, when it comes to regulated entities like investment advisors and broker-dealers, the case represents an example of the staff getting pretty deep in the weeds on controls. Not a case asking whether or not there were controls. Clearly there were, but whether they were enough. And, this sounds like a trite phrase among lawyers, but it's true, the importance of documentation. If your policies say you're going to do a review, well, if you don't document it, it's as if it never happened. And so if it's important for you to do a review, then it's important to document it and document it well. So when looked at, at some point later in time, you can show that it really happened.
And I thought it was interesting. I mean, it was a $1 million penalty, that's a pretty significant penalty given the company had policies in place and made some efforts.
What do you think, Joe? I mean, that's a pretty onerous result, $1 million penalty. I know you're not here to defend necessarily the commission's decision making on it, but where do you come out on Ares?
Well, I mean, I think that the takeaways that Rob mentioned, and this is not a case that I personally worked on, so I'm kind of free of knowing all of the details. But I also read the order, and I think the takeaways are important. I think in the first instance, just one other thing that maybe Rob didn't emphasize is that having a policy not to trade during a blackout period is appropriate, but certainly not sufficient. There are all manner of different ways that someone at a board level obtains material non-public information, throughout the course of serving on that board. And it's not just in the times leading up to quarterly earnings announcements. So I think that's an important thing to keep your eye on if you're designing a policy. But I think another aspect of this was the relationship between Ares and the portfolio company, and the fact that it wasn't just this one director who maybe received material non-public information, but but a more extensive group of people who were involved in various deal work, and making sure that that all of those people that the knowledge that they had was taken into consideration as well. And so, I mean, I think it really goes back to 204 Cap A and the idea of understanding the business that you're in. Understanding the possible sources of material non-public information that you may have, and designing and implementing appropriate controls around that specific situation that you find yourself in. And I think that in the light of that, and in the light of what Rob mentioned about the lack of documentation. Under circumstances where documentation was required under the policies, I think that it sends a strong message, but not overly strong, in my view.
Dan, you're on mute. You're still on mute.
We have one topic left. And that is insider trading in the time of COVID. We're all working from home, and we recognize that many insider trading cases begin where information is obtained or shared with family members or friends or people close by. What are your thoughts about, and this is to the panel as a whole, as to what the risks are with respect to potential insider trading and the enforcement response in this post-COVID world?
Yeah, I'm happy to start. So, I mean, I think, Dan, you're right. I think there's multiple risks. One is what you just mentioned, which is people now have all their work material at home. And, there's already been cases in the past about, fiancés or boyfriends or spouses trading based on information that, was either overheard or glanced at, or maybe even a house guest seeing information. That was already an issue at times. Well, now with everybody having their entire work life at home, and we've been home for 6 months, so people have documents printed out, and people are having Zoom calls or WebEx calls. There's just whatever that risk was already, it's now been magnified. I think the other type of risk I'd mention is that because of the pandemic's effect on the economy, you have much more volatility in financial performance among public companies. So, again, there's always a risk that people inside a public company have MNPI. But, typically most companies have sort of a rhythm to their earnings. They have a decent idea of where they expect to be, and, whether they're a little above or a little below is obviously important. Some give guidance, and the guidance gets updated, but there's sort of a fairly, well-known, internally well-known expectation. Well, now with the pandemic, there's much more volatility, and so it's much more likely somebody inside a company will know that, hey, we're not recovering as well as our peers, or hey, we may lose a big contract because we're missing milestones, things like that.
Yeah, I would think if you're a company in this time period, you really want to make sure that your insider trading policies are up to snuff and revamped to kind of deal with this issue of people doing Zoom calls, maybe a room or two apart, and company documents being, or in piles around the house or what have you, and to put some hypotheticals in their training and things like that to try to alert people to the risk and to try to prevent, something bad from happening.
I see Bruce has joined us, so I guess that's our cue to wrap up.
Thank you, Dan. Great job, and great job, panel. Really interesting update on insider trading, what's going on right now. So we'll be back at 2:30 with a one-on-one conversation with the SEC's Matt Jakes. See you in a few minutes.
Thanks.
Thanks.